Hello, and thank you for joining us on today's Ask Andrew show, Canada's first Facebook Live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the managing partner here at Feldstein Family Law Group in the Greater Toronto Area. We practice exclusively in family law in the province of Ontario. If you're watching it elsewhere, you may find some useful information as well. Today, our special guest is Canadian Divorce Financing President Todd Werboweski, and we'll be discussing divorce financing options for Canadian residents. Please feel free to ask questions in the comment section. Now, I know to some people it may sound like it's not that exciting to talk about divorce financing because most people like to talk money as much as they want to talk about paying taxes. But the practical reality, one of the most challenging areas in family law has been access to justice. And from what I understand of what you do, Todd, you're actually helping facilitate for a lot of people to have access to justice. And can you tell me a little bit about yourself and your business and what it is that you do?
Well, Andrew, I thank you for having me. I started 19 years ago in the finance industry, and it was always frustrating to me when you would sit down with a couple and work with them over years to develop a good net worth for these people for their retirement. And then they go through a divorce. And unfortunately, all the work and all the effort has been for nothing because they make a very emotional decisions and quickly go through whatever finances they have. When it came to my own divorce, I actually ran out of money twice and started to do some research and realized that this is a concept that's widely used in Europe, catching on in the United States, but not yet available in Canada. So with my finance background in hand, I decided to wade into this and start to do some market research and realized that almost every single person that ever sat down with me all had the same comment. If I had more money, I would have done it differently. And it started to snowball from there to what we have today. So we originally started with just a trial base in Alberta where our head office is located. And we worked with 6 firms here in Alberta just to make sure that we had the mechanisms working correctly. And from there now we're doing a Canadian, well, about 8 months ago, we did a Canadian rollout and the uptake has been tremendous. There's obviously a need for this. We find over 50% of our client base is the stay-at-home mom who doesn't even qualify for legal aid because they've been living in a home for 20 years and they have too much equity. But yet they're, house rich, cash poor. So on top of the stress, how does this person even achieve, financing to get proper legal representation?
Okay, well, I know I experience the challenge of hearing from my clients, how are they going to afford their legal expenses? Because from their perspective, it's frequently they have a personal line of credit, and if they run out of their line of credit, they may be, in their mind, out of money, and you're saying you're able to provide an alternative. Do most people qualify for financing?
Most people that have assets or they have what we're actually rolling out now is because we found there was a lot of people that maybe sold the home and the money's sitting in trust currently. So they have no security. So even to go for a traditional loan, they wouldn't qualify. Or those that, they were never on title of the house for whatever reason. So we actually came up with a way now of working with their friends and family. So we can actually use the security in those people's homes. So it's opened up our client base quite a bit so that before there was about 20% of the people that applied do not qualify. Now we're actually getting it down under 10%.
Well, that's wonderful. And how does the application process work?
Well, once we get authorization to talk to you, the legal professional, and have an agreement in place between Canadian Divorce Financing and the client, then we take a look at their assets and liabilities, just to understand what position they're in. And then we can give what we call a global limit from that point on. They don't need to borrow up to the global limit. So we just had a woman that qualified for $320,000, and she goes, no, I need 40. well, that's fine, but the money's there if required. So we actually find that there's more and more uptake for people who not only borrow just for legal expenses, but for ongoing living expenses. They're coming short on a month-to-month basis. So once we understand where their wish list is, then we can put together the financing documents and actually put it through. If everything goes smoothly, the entire process takes about a week, and the money's put into the lawyer's trust account, since this is designed for legal financing.
So this gets me thinking of certain questions. I picture a client, they say to me, Andrew, I need money, you know, do you have any ideas? And I say, why don't you call your organization, and they phone you. What happens in that first phone call, and how do you walk them through the process?
Well, the first phone call is basically getting an understanding of their financial position. Obviously, if somebody has no assets and they have no nobody there to support them, and unfortunately, then we do have to say no. But like I said, that's slipping in percentage quite a bit with the people that we're running into. So once we get a general understanding, then we actually get them to take on the requirements of an asset and liability worksheet, so that we can get a good understanding of their full spectrum of finances. And then from there, we work with them very quickly to find what we can use as security and how much they need. Like I said, the global limit. And then once that's done, the application process takes just a matter of a couple days, and financing is usually within 48 hours of approval. So
now, if I was that client, I would be wondering, what do you charge for this?
Well, we do have a 5% fee on anything that we do finance. The thing that we're actually very happy to announce today, that we're actually offering a rebate if so we set it up normally on a 12-month term. If the people are able to repay it in 9 or 6 months, we're actually able to give them a rebate back on the fees, depending on how fast it comes back. Because we want to encourage that this money is only going to be used for the divorce. And we find that most people, once there's a polarity in assets available to move forward, the other side quite often will sit down and start to negotiate. It's the war of attrition that most people find the most frustrating. And suddenly, when they get an infusion of capital and the ability to, present their side, is when the other side wants to sit down and have a good discussion. So from sitting down and understanding their financial position to realizing what we can actually help them with, the intake process is just a matter of days.
So I take that example of the client you mentioned earlier. She said she borrowed $300,000, I think, or $320,000, but she commented she only needed $40,000.
No, she could take up to $320,000. So the global limit is there in case something happened, the fight goes on longer than they thought, extra expenses for, say, suddenly the other side's asking for a bilateral assessment, or there's suddenly you realize that there's money being hidden, so you have to go after a forensic accountant, that sort of thing.
So I was wondering, the 5% you mentioned earlier
is only on the amount taken.
Okay, that would be a really important question to me.
Yes, yes. And the closest competitor that we have in Canada actually charges 2% a month compounded monthly. So it works out to about 28.8% annually. We charge anywhere from 6 to 12%, depending on line of sight to the asset.
So that was going to be my next question, was what's the interest rate? Because I know that's what my clients would like to know.
Of course, they do, yeah.
And a lot of people have said to me in their minds when I've talked to them about this topic, it's almost competitive with a credit card, because a lot of clients will pay with credit cards and carry their credit cards. And when I hear 6 to 12%, it says to me you're well below a credit card interest rate.
We're not only well below, but we can also set up, about 92% of our loans right now are set up with zero payment. So we actually had one recently where this poor woman put $62,000 on her credit card for legal expenses. So you can imagine the financial strain of going from 2 incomes down to 1, still maintaining a family unit, but now adding on $2,300 a month in interest expenses. So what we were able to do is when she finally hit the wall and felt like there was no no future for her when her lawyer asked her for another $20,000. So we were actually able to wrap the whole thing together, pay out the existing credit card debt, and have it so that she has no payment, so she can maintain her lifestyle and the children's lifestyle during the divorce period.
So from that perspective then, what makes you determine between 6 and 12% as the interest rate?
Well, 6% would be, say, family home, no other liens against it, no other financing against it, and we can cast over their half of the equity in the matrimonial property. Where it gets a little bit more complicated is, for example, we've had individuals want to put up company stock. So, you know, the risk for us is a lot higher in those cases. So it really is a risk ratio that we look at. I want to keep it as low as possible for our clients. There is no shortage of clients. As you know, there's 71,000 new divorces filed annually in Canada. It's not going away, and we just want to help those people that we can. I've actually helped a couple people just to get, you know, second part or third party loans, you know, because if it works for them, then by all means go for it. But the financial planning side is something that is a definite must.
Now, we just got a question on Twitter. Is there a minimum loan amount?
At present, we've not done under $20,000. The highest amount was $12,000. So we can take applications anywhere between those two amounts.
So what happens if you have a client who says, I'm keeping the house?
We actually had that situation, yes, where in a four-way meeting, she decided, forget it, he can keep all the assets, just give me the house, give me the kids, give me the house. We are licensed mortgage brokers for across Canada and the United States, so we actually put a mortgage in place. And we're actually, because of that, we're able to, once everything was finalized and the CLPs were released, put the mortgage in place and have everything paid out. And then obviously there's a much lower interest rate. So part of our process is making sure that there is a back end that we can actually help these people to get out of this. After all, once your divorce is finalized, you don't want to end up with a loan for, you know, the next X amount of years.
So in other words, you try to be creative to help them, that if they want to buy their former spouse out of the home, you may be able to make that happen for them.
Exactly, exactly.
That's
because
wonderful.
You know, everybody has a reason why they make the decision of their requests. Whether you or I understand them, it's up to the individual. So we just try to accomplish getting them through the divorce process and then on to their life after.
Now, I'm going to ask you a question that comes more from my vantage point as a lawyer. Here in Ontario, there's something called interim disbursements. And what that means is if my client doesn't have any money and the other side has a lot of money, I can go to court and I can ask a judge to make the other side advance money so I can fund the litigation.
Yes.
And one way to stop that is saying, and I've done this before, well, there's a line of credit that's secured against the home, just access it and pay the interest, and that should be good enough. And the court seemed to accept that. Have you had anybody come to you and say, this isn't for my client, but I want to find out what it would take for you to finance my former spouse's litigation because I don't want to have to lend them the money. I'd rather you lend them the money.
No, that's actually something that we have not run into where somebody's requested financing on the other side. That's an interesting concept. It would still require the person that would become our client to sign all documents. But you know, as you're aware, as long as there's a financial tie, there might be a reason why it would be a prudent thing to do.
Because I could see if one of my clients was on the receiving end of that kind of motion, I would write to them and probably say, you should be contacting these people and even and telling them they should be reaching out to you to borrow the money, because better, as I said, better you lend it than my client write a check what may be lending or may not be lending.
Well, it's always better to use a third party's money. It's just like from my days of financial planning to leverage rather than put a couple $100 a month away. You're going to end up with a much better position if you use somebody else's money to get to your goals. That's the whole idea of a mortgage or anything else. So if it makes financial sense for that, then of course we would proceed in good faith, and as long as both sides, as long as our client in this case would be in agreement, I don't see why it would not proceed in a timely fashion.
Okay, now we did get another question that came in on Facebook, and this is from Ivana. She says, does my lawyer have an obligation to continue acting on my behalf even if I don't have any retainer left on file? And the answer to that question starts with, usually they don't have to continue working on your file. However, if it's on the eve of trial or on the eve of a significant event, they have to continue. And if they are your solicitor of record, they have to continue until they're not your solicitor of record. And if your lawyer asks you to sign a notice of change in representation for you to act in person, you can refuse to do that, but then you face the risk of your lawyer bringing a motion and seeking costs against you. And if your lawyer has to do more work, they may still be billing you and looking for you to pay them for that work. So there are problems with insisting that your lawyer continue to work for you even after you've run out of money. And in fact, and I'm sure Todd would agree with me, this is where his kind of role becomes perfect, because there's a lot of clients that get into the process and, as he said, are asset rich, but cash flow poor. And this gives you a wonderful option. On Twitter, we got another question. Can both divorcing spouses get financing from you? I love that question.
We do have to be careful in that circumstance. We are morally and to some degree legally obligated to ensure that we're not allowing funding to continue an ongoing fight. The whole premise of this is to get to the other side. It would be no different, though there's no difference than if they were to both walk into the Royal Bank and get funding. So the answer is yes, we can. We have. But we have to make sure that we're properly secure in the idea that this is just to get through to the other side and not just to have a fight in the courts.
Well, part of the reason why I like that question as well is sometimes we've had clients, and I can think of cases where they both may want to have financing, which could be to pay the realty taxes on the home. It could be to pay lawyers and expenses, but they don't qualify for a mortgage. But they both want the financing. So they may both come to you even jointly and say, can you lend us money?
Well, the situation we had was fairly similar. One side needed to pay out Revenue Canada so that Revenue Canada released a claim on property so that he could turn around and sell the property and then pay the support arrears so that they could actually finalize a few different components of what they were trying to go to court for. So it was a real house of cards that we were happy that we were actually able to come together and help both sides.
Okay, here's another one from Facebook, again for Todd. What type of financial disclosure does someone need to provide to your company?
Well, we need to take a look at what assets are available. We like to do like what we call our asset and liability worksheet. So we take a look first at your monthly budget to see that if you're actually able to maintain a loan if it was to turn to that. Like I said, over 92% of our clients, the loans are set up so that it's zero payment during the period of the loan. But once we take a look at that, then it's looking at what we can use as security for the loan. There is still some form of security that we do have to have. So then it's making sure, for example, you're on title for the mortgage, you're on title for the property, that you're listed on the mortgage, that sort of thing. So the basic papers that you would do for any loan for any other facility, financial banking that you would do.
Okay, can you describe a good story about people you've helped?
Oh, actually, in Toronto, a stay-at-home mom was 2 years, or the ex-spouse was 2 years in arrears on support for both child and spousal. She had a disabled child as well as another child, was not able to work, and was in the point of foreclosure on the house. He wasn't making any payments on the mortgage as well. So we were actually able to finance and put together everything. And it was the first time that I actually had somebody crying on the phone saying thank you. We get a lot of thank yous, but when somebody is realizing that they're not going to be kicked out of their home, they're going to be able to get on with their life, and they're going to be able to look after their children in a manner that the kids were used to before the divorce, really means a lot to me. Like I said, I went through a high conflict divorce myself, and I know to me the priority is getting people through to the other side, and seeing the financial decisions that people make in an emotional state, and then seeing how we can help those people, is one of the most powerful things that impacts me on almost a daily basis.
Okay, I'm sure it feels good when you hear the crying voice at the other end and appreciation, because I know when I get that kind of appreciation, it's a really great feeling, and it makes you feel like, as a family law lawyer, it's one of the reasons you got into the business was because you're actually helping people, unlike other areas of law.
Exactly.
Is your service available across Canada?
Yes, it is. We've actually everything everywhere from Vancouver to Gander, and everywhere in between. The process is only slightly different, just being the fact that we have different documentation for the different provinces. But other than that, the process is the exact same.
And would it be sufficient for you when you look at the financial information if the client said, well, I'm going to have my lawyer send you my sworn financial statement?
Yes, that's actually something that we do. One of the first forms that we get the client to sign is a communication consent, so we can actually talk to the lawyer. There's no point in doing the same job twice. For the lawyer's assistant, quite often it's a matter of copy and paste the information over, or just the sworn financials in most cases.
See, my concern, I put on my hat as a lawyer when I'm looking at someone who's self-employed. I frequently want to see their credit applications and statement of net worths they're filling out to third parties, because I want to see if it's inconsistent with what they're telling me in the family law proceeding.
Yeah, and there's no obligation, obviously, for either side to disclose. But I know I would sure want to know a little bit of information. Say if a client was to disappear, that's never happened. But I'm sure as a family law lawyer, if your client was to do something not in their best interest, you would be advising them, just as I would be advising them, to maintain the course and stay on track so that we can get them through this process.
Well, what I'm concerned about is I know I can get a court order if I go to court seeking the disclosure to have the third party, or have the client sign a direction to allow the third party to release their financial information to me on the credit application. So I'm always mindful of what would go to you may go to my former spouse. And that's why I'd want it to be the financial statement, because it would be the exact same thing that I'm presenting.
Yeah.
Here's another question. This on YouTube. I owe my family lawyer money for a divorce that is now finalized. Can I still finance?
If there's an equalization payment that is still outstanding, then yes. If not, then your probably best bet would be to achieve proper financing, like to go to your bank and see how they can assist you. The real methodology here is so that at the end there is an equalization payment, that part of it is used to pay out the loan and part of it is to get you on with your life. So it depends on your unique situation, but that's not enough information for me to make a proper assessment.
Fair enough. We had some questions before the show, not necessarily related to what you do, but I'm going to read them out so I can try and respond to them in the last few minutes we have. The first question was, if someone was married, but they only had the room they were being married in for about 20 minutes, and the pastor didn't ask or tell them to say vows, and the wedding wasn't consummated on their wedding night, is it still a valid marriage? Well, I'm assuming that the marriage has been registered with the provincial government that you were married in. So if it was in Ontario, the proper paperwork has been filed. And if you want to find out, you can go on Service Ontario and request a copy of your marriage certificate. If you have a marriage certificate, that certainly presumptively would suggest that the marriage was valid. In terms of the question about whether you consummated the marriage on the wedding night, this is one of the myths that exists. People think that they have to consummate the marriage in order for the marriage to be valid, and that's simply not true. The test is that you have the ability to consummate the marriage. So if you have the ability to consummate the marriage, that's enough. whether it took place the night of, 2 weeks later, or never took place. It's all about the ability. So I hope that question is going to help, because I think that if you're married for a number of years and you try to say, well, I didn't say all the vows, I'm not sure that that's really going to be believed by anyone, especially if you've gone around representing yourself as a spouse. The second question is, do I need to retain a lawyer and an accountant in order to sell my home in Canada, even though I'm a citizen of Canada living in another country? This really is less family law and more real estate, but the simple answer is you need a real estate lawyer to sell property here, and you will need an accountant, because if you're a non-resident in Ontario, there's going to be, or non-resident in Canada, there's going to be withholding taxes, and you probably will need an accountant to deal with it, but that isn't my area of expertise. The third question we got before the show started, as I'm trying to get through these in rapid fire, is Twitter. And in that one says, what if a spouse intentionally quit work claiming illness and job market, has a PhD and can't prove he is disabled, yet quits paying child support for over a year? During that time, bought a home to support a new woman and her 3 kids using inheritance money for living expenses. Great question in family law. And the point is, you can't just quit your job and say, I'm not feeling well, and don't pay support. If you truly have issues that you're not well and you can't work, then one would assume that you're seeing some medical doctors, or if you're depressed, you're seeing a mental health professional, and you're going to be able to document that evidence. And in fact, one of the first things whenever you say to a judge is, my client can't work for health reasons, they ask if they applied for CPP disability insurance. Because A, if you're applying for it, it's a statement you are disabled, and B, CPP doesn't like to hand it out like it's candy. They actually are pretty strict with it. And if CPP disability is paying, in the back of a judge's mind, presumptively, they're going to believe it. But if you're not getting that CPP disability or some other form of disability insurance, there's going to be a very skeptical view, especially if you have no medical evidence and you're not getting disability, you're not going to get anything. And a court can then turn around and say, because under the guidelines, you have an obligation to maximize your income. And under the guidelines, that means that you actually have to work as hard as you can to earn your income, and the court would impute an income to that gentleman based on what he earned prior to quitting his job. We just got another question came in, and this one is, if a lawyer discovers hidden income that was not disclosed to a financing company, is there an obligation for the lawyer to disclose? I'm assuming that the question relates to, if it's my client that's borrowed money and it's my client that didn't disclose it, do I have an obligation to disclose it to Todd?
We work on the disclosure that's provided by our client's lawyer and by the client themselves. It's no different than if somebody was to mislead on a mortgage statement while it being illegal. There's not a lot of recourse unless we can prove otherwise. So we are tied by the information that is provided to us by our client and their legal professional. In most cases, the legal professional has an obligation to provide truthful evidence. But I've seen some very interesting situations in the past.
So then that leads me to this question. As part of the process as a lawyer, if one of my clients is borrowing money from you, do I have to sign an agreement in terms of disclosing information with you? Obviously, I'm not going to be financially responsible, but is there some sort of agreement between the lawyer and your company with respect to financial disclosure?
We are no different than if the client received money from Aunt Nellie, or if they had walked into the bank and received financing from their normal bank under normal situations. So there's no obligation for you to disclose. Now, if they choose to and try to go after the other side for costs, so for example, interest costs and financing charges, that's up to your client to decide with you. But as far as your obligation, no, we're not aware of any.
Okay, that's actually a really good question for understanding the circumstances of that type of relationship. I wanted to thank you, Todd, for being on the show today. I thought it was a fascinating show, and it's been a pleasure having you.
Thank you, Andrew. I appreciate the time.
And for anyone who's interested in Todd's Canadian divorce financing services, please visit him at his website at www.canadiandivorcefinancing.com. And I would even suggest that if you have a friend or a family or your that is going through this process, you may even want to go onto our Facebook page and send a copy of this show and share it with people who may need Todd services, whether you're a client of this firm or not, because this may be a great way for someone to understand what it is that Todd does. We're going to keep you posted for the next Ask Andrew show, which will be in January. So happy holidays to everyone. Happy New Year. And if you have any questions or ideas, please email them to us here at info@feldsteinfamilylaw.com. And thank you for watching.